The old cliché goes that only three groups can't vote: lunatics, lords, and felons. But there isn't exactly a legal definition of lunatic these days, and it turns out you can vote by post, even if you've been sectioned. That leaves two groups with some overlap. But the lords will soon stand alone if the European Court of Human Rights has its way. They declared the UK's blanket ban on prisoner voting to be unlawful and have insisted upon action. Despite it making David Cameron physically sick, the government has obliged, and a draft bill is in process. This has caused some serious annoyance.
Why are we even having this debate? No one in Britain has been talking about this for years. The only reason we're having this debate is because a bunch of unelected, unaccountable judges in Strasbourg, half of whom had no prior judicial experience before they became European judges, have said on a whim, with no basis in the European Convention, that actually they're going to start telling Parliament what to do. That is a very poor reason, in my mind, to ramp something up the political agenda.
The British Parliament has accepted an overriding authority to the court in Strasbourg where there is a clear breach of human rights. But what was in the minds of the drafters of the statute and of Parliament when we ratified the Convention was torture, cruel and unusual punishment, failure to respect basic elements of trials, deportation to countries where it's dangerous and so on. Those are basic human rights. Whether people vote who are in prison is not a basic human right, and therefore the Strasbourg court should keep out of this.
Dominic Raab, Jack Straw and David Davis are all determined that the law should not be changed, and have submitted evidence to the Bill Committee demonstrating this. They say the ECHR is trying to move beyond its limited mandate and is encroaching upon Parliament's powers and responsibilities.
The European Court of Human Rights has moved from having a narrow focus on human rights to becoming an overarching Supreme Court for Europe without any mandate for that and without any democratic override, where the court makes a decision which people in an individual country object to.
I don't mind, in a sense, Strasbourg saying to Parliament, are you sure you've looked at this? As long as in the last analysis and ultimately we have the last say, and I think that's the point of principle.
When the ECHR originally made this judgment, they stated that the UK had not considered the prisoner voting issue properly in recent times. Presumably they tasked an intern with researching this.
That was completely wrong. I mean, we had looked at it. Indeed, there had been a working party which considered this amongst other voting issues. In the first Blair administration, when I was Home Secretary, that working party was chaired by one of my ministers, George Houth, and it led to some changes in an act in 2000. So it's completely untrue that we hadn't looked at it.
That rather undermines the credibility of the court, doesn't it, to not see something so recent in history?
Yes, and it suggests, I think, that they had red mist when they went for this issue, or a majority of them had red mist. Because the other thing that distinguished the Hearst judgment was that a minority, the more experienced, more senior judges, were all against the court assuming jurisdiction.
The European Court judgment was 8 years ago now, and pressure to do something has been maintained, hence the draft bill. Clearly this issue is being taken seriously in Europe, so could we face repercussions for ignoring it? There are fears that the European Court could award compensation to prisoners if we prevent them from voting.
Well, I think there's all sorts of threats and blackmailing tactics and techniques that are coming out, but the fact of the matter is compensation awards cannot be directly enforceable in the UK courts under UK law. So really the worst, the other people are saying, well, we'll get kicked out of the Council of Europe if we don't obey the Strasbourg rulings. In fact, the very worst that will happen is that rulings like this will end up with what's called the Committee of Ministers, the same committee, by the way, that's told Strasbourg to stop meddling so intrusively in national parliaments, and we might get a light diplomatic rap on the knuckles. But we've actually got a very good record of complying with human rights in this country, and I don't think we should have anything to fear.
So what happens now? The bill has three options. The first is to let prisoners serving less than 4 years vote. The second is to let prisoners serving less than 6 months vote. And the third is to maintain the current ban. Will anything actually change?
it has the feeling that this issue is in the long grass. I think the government are in an awkward position. It's very clear Prime Minister does not want to do this. It's very clear Parliament's got no intention of doing this. So it's frankly a bit of sort of cosmetic consideration, whereas I suspect in the next year we'll get to the same result as we've had before.
We believe that the European Court of Human Rights are determined to try and get a major concession out of the United Kingdom government and Parliament, so that we have acknowledged their authority. And so, given that I think their appetite well exceeds anything that can be delivered in the British Parliament, it is better to stand on the principle and say thank you very much, but look, this is not a human rights issue, it is not what this convention was ever intended for, it's a matter for the British Parliament.